On Christmas Day 2021, while many people were at home with their families, the European Space Agency launched the James Webb Space Telescope. It was a huge team effort between different aerospace agencies. The launch went perfectly, and since then, James Webb has sent us amazing pictures of galaxies, stars, and planets far away from us. Before James Webb, there was Hubble, and when Hubble was launched, there was a problem. A very small error in its main mirror made the telescope short-sighted. Interesting, eh? The most advanced telescope ever launched into space was sending back blurry images. Only after a very risky space mission where astronauts installed special corrective lens did Hubble finally start sending the beautiful sharp images that we know today. Right now, the EU digital rules are in a similar situation. The rules are powerful, but the image is not always clear, and the Digital Omnibus package is supposed to be the corrective lens. Welcome to a new episode of Diritto al Digitale. I'm Giulio Coraggio, a technology and data lawyer at the global law firm DLA Piper. Diritto al Digitale is the podcast where we explore the intersection between law and innovation. In this episode, we talk about the Digital Omnibus package. This is a proposal of the European Commission to simplify and improve many existing EU digital laws. Why the EU felt the need for corrective lens, what changes are proposed for the EU AI Act, the Data Act, the GDPR, and cybersecurity rules, and what this could mean for companies that use digital technologies and AI in Europe. I will try to make clear indications and provide you just information that you need. So, why do we need a corrective lens? In the past 10 years, the EU has created a constellation of digital laws. For example, GDPR, the main EU privacy and data protection law, the EU AI Act, the new law on artificial intelligence, the Data Act, rules on access and sharing of data, NIS2 and the Cyber Resilience Act, that are laws on cybersecurity, DORA for the financial sector, ESA and DMA, rules for online platforms and big tech gatekeepers, and the EIDAS 2.0 on digital identity. On paper, all these laws have good goals: protect people's fundamental rights, make technology more trustworthy, and create a fair digital market in Europe. But in practice, many companies and even foreign governments see Europe as too complex. Why? For example, different laws cover similar topics. The same incident might need to be reported under the GDPR, NIS2, DORA, and other rules. Definitions and concepts are not always aligned. Enforcement can be different in each EU member state. So the EU legal framework is powerful, but sometimes the image is blurred, like Hubble at the beginning. The Digital Omnibus package is meant to fix the optics, not to change the whole telescope. So, what is the Digital Omnibus? On the 19th of November 2025, the European Commission published two linked proposals, often called together the Digital Omnibus package. The idea is not to create one more big new law, but to simplify, clarify, and improve the laws that already exist, make them work better together, and reduce unnecessary administrative work for companies. The focus is mainly on AI and AI Act rules, data and data sharing, for example, the Data Act, GDPR and e-privacy, in particular cookies and AI training, cybersecurity, and incident reporting under NIS2, CRA, DORA, and others. One key idea is report once, share many. This means one single entry point for incident reporting at EU level instead of multiple different portals and forms. So, let's now look at the main areas that have been addressed with simple explanations. The EU AI Act. The idea is to make rules more realistic. The AI Act uses a risk-based model. It bans some very dangerous uses of artificial intelligence, creates strong duties for high-risk AI systems, for example in health, employment, critical infrastructure, and imposes lighter rules for lower-risk AI and for general-purpose AI models. However, AI providers today must also comply with the GDPR, product safety rules, sector rules like financial or health law, platform rules like the DSA, and cybersecurity rules. This can be heavy, especially for smaller companies. The Digital Omnibus package proposes some targeted changes to the AI Act, for example, on AI literacy. The responsibility for AI literacy would move to the Commission and to the EU member states. This means that not every company would have a very strict legal duty to train all staff on AI, but for high-risk AI, human oversight still needs to be done by people with right training. There will be a simpler registration. Some high-risk AI used only internally and with low risk may not need to be registered in the EU database. There will be more proportionality for middle and small companies. There will be more concrete relief and flexibility for small companies, recognizing that they do not have the same resources as big tech. And there will be more time for existing systems. For the high-risk AI already on the market, application of some rules could be delayed. This is to give time for standards and guidance to be finalized and for companies to adapt. There would be adjustment on post-market monitoring guidance. Monitoring, the Commission would issue guidance instead of very rigid implementing acts. So companies have some flexibility on how to monitor AI after launch. And there would be a stronger EU AI office. For very sensitive systems, for example, systems built on powerful general-purpose models or used by very large platforms, the EU AI office would have more powers. It could coordinate enforcement and even run pre-market tests to avoid 27 different interpretations. There is also an important data protection element. Under conditions and safeguards, some residual processing of special categories of data may be allowed for AI development and operation. If these changes are well written, they can make the AI Act more practical and more acceptable for innovation while keeping the focus on safety and rights. And if they are too broad instead, they may look like a late discount on compliance and could weaken trust. Then there are changes to the Data Act and data sharing. The Data Act wants to make data more accessible and shareable, for example, giving users rights to access data from connected devices, requiring fairness in some B2B data sharing terms, allowing public authorities to access data in special emergency situations, making it easier to switch cloud providers. But when you combine the Data Act with the Open Data Directive, the Data Governance Act, and then think of cybersecurity and trade secret protection, the result is complex. The Digital Omnibus package tries to make public sector data access and reuse rules more consistent with the Data Act, refine cloud switching rules with model clauses and special treatment for certain cloud services and small and medium-sized enterprises. Clarify when third-party risks, for example, risk of access by foreign authorities, can justify saying no to data sharing. Make some data intermediation obligations more flexible, moving from a mandatory to a voluntary regime in some cases. For companies working with data, cloud, and IoT, this could mean fewer overlapping rules and clearer in structure, but it does not completely rewrite the system. There will be also changes to the GDPR. This is probably the most sensitive part. The Digital Omnibus package touches GDPR and e-privacy in several ways. Let's focus on three big topics: personal data and pseudonymization. The proposal refines the way we look at personal data and pseudonymized data. It introduces a more context-based test. Can a specific actor realistically re-identify a person? If not, some data may be treated as non-personal data for that actor, as it was clearly stated by a recent decision of the European Court of Justice. This could open more space for data reuse in practice, but it also raises questions. Who decides what is realistic? How do we prevent abuse? Another area in which the GDPR is going to be amended, or probably will be amended, is on the usage of legitimate interest for AI training. The Omnibus package clarifies that under some safeguards, such as transparency, data minimization, rights to object, legitimate interest can be used as a legal basis for the development of AI systems and models and some operations of AI. For AI providers, especially for large language models, this is an important signal. In fact, today, many are in conflict with data protection authorities on what legal basis they can use. However, the word operations is very broad. If not defined well, it could read as almost any processing done by AI systems, and this worries many privacy experts. The Digital Omnibus package also introduces a limited exemption for sensitive data that is present in AI datasets in a very small and accidental way, when removing it would be extremely hard and expensive, and where strong protections are already in place. The third change impacts cookies and the so-called consent fatigue. Everybody is tired of cookie banners. The Digital Omnibus package proposes that for natural persons, the GDPR would govern much of this area. Browsers or operating systems could send automatic signals with the user's preference. For example, I refuse tracking cookies. Websites would then have to respect these signals instead of asking for consent every time. However, media and news sites would have a special treatment to protect ad-based business models. This is already controversial and will probably be heavily debated. Other changes impact the creation of a single EU breach reporting portal with a report once, share many approach and a slightly longer deadline, 96 hours instead of 72. There will be clearer rules on automated decisions under Article 22, making it easier to rely on contract necessity. There will be the possibility to reject clearly abusive data subject access requests. There will be some exemptions from transparency duties in low-risk cases where the individual already has the necessary information, and harmonized DPAA lists and templates across the EU. All these elements aim to reduce administrative work and create more consistent rules. The risk is that, if not communicated and drafted carefully, they will be seen as a slow erosion of GDPR protection. The last pillar relates to cybersecurity. There will be one portal instead of many. Today, after serious cyber incident, a company may have to notify under NIS2, the GDPR if personal data is involved, the Cyber Resilience Act if a product is affected, under DORA for financial entities, plus any sector-specific rules. Each law have its own deadline, portal and authority. The Digital Omnibus package supports the creation of a single entry point at EU level, managed by ENISA with one harmonized incident notification template. Report once, share many. Logic: the report is then shared with the right authorities. This could save a lot of time and reduce confusion for cyber and legal teams. But of course, this central EU portal itself must be very well protected and well staffed, because it will become a prime target for attackers. The big question is, will this really fix the optics? So, can the Digital Omnibus package be the Hubble corrective lens for the EU digital law? Most serious companies want strong, clear rules. They know that privacy and security build trust, clear AI and data rules reduce gray areas, and predictability helps investment and growth. The EU's objective, a digital market that is values-based and innovation-friendly, is the right one, but clearly it's essential. The Digital Omnibus removes real overlaps instead of just changing article numbers, makes small precise adjustments for the AI area, aligns language, and goes through a transparent political debate, then yes, it can really help for both regulators and businesses. If instead it's quickening rights or is helping only large players with big compliance teams, it may create more legal uncertainty and more conflict. What is your view on the above? What's gonna happen with the Digital Omnibus package? Just drop me an email at giulio.coraggio@dlapiper.com. Let's discuss. Also, if you like this episode, please follow the podcast, activate the bell so you don't miss the next episodes, and leave us 5 stars on Apple Podcasts or Spotify. If you find it interesting, it really helps more people discover Diritto al Digitale. I'm Giulio Coraggio, this is the podcast Diritto al Digitale. Arrivederci!